And Scott, I'm going to turn over to you. Thank you very much for joining us.
Thank you, Wendy, and good morning, everybody. Thank you again for joining us today. As Wendy indicated, the two main topics that I'm going to be talking about today are the following. Families First, as we know, hopefully you should know, expired on December 31st, 2020. What, if any, legal obligations do we have to continue providing paid sick or family leave to eligible and qualified employees? And then the second topic is the vaccine, right? And as Wendy alluded to, answering kind of the big question that many employers are faced with now, considering we are in phase 1B, is that can we mandate that our employees get the vaccine? In other words, can we implement a mandatory COVID-19 vaccine policy? So we'll answer that question for you and then discuss a lot of other ancillary issues that go along with both of these two topics. So with that, let's get started. So as we know, right, Families First, it required that covered employers, and remember covered employers as defined under Families First was if you have less than 500 employees, so 499 or less, you were required to provide paid sick or family leave under either the Emergency Paid Sick Leave Act and or the Emergency Family Medical Leave Expansion Act. Now, that was a temporary law, right? It went into effect on April 1st, 2020, and it expired on December 31st, 2020. Sadly and unfortunately, the need for both sick and or family leave continues for our employees. So the question that we're going to answer in a couple of seconds here is, as of January 1st, 2021, are covered employers, again, if you have less than 500 employees, are you required to provide paid sick or family leave to eligible employees under Families First, i.e. under the Emergency Paid Sick Leave Act and or the Emergency Family Medical Leave Expansion Act? And so we'll look at our crystal ball here, and survey says no. As of January 1st, 2021, you are no longer required to provide paid sick and or family leave to employees, even if they're eligible and or qualify for it. So let's break that down for you. First, why is this? Well, one, as we know, Families First expired on December 31st, 2020. Couple days before that, December 27th, 2020, then President Trump signed into law what is called the Consolidated Appropriations Act. And why is that act relevant? It's relevant because of the many provisions in that particular act. One provision addressed Families First. And that specific provision says that as of January 1st, 2021, if you are a covered employer, you may now, the operative word here being voluntarily, you may now voluntarily provide Families First paid sick or family leave to qualified employees through March 31st, 2021. And if you do so, you can collect payroll tax credits. Now, as of right now, that March 31st deadline is set in stone, but with the new COVID relief stimulus package being discussed, we'll have to wait and see whether or not there's any extension of that particular date. But as of right now, consider March 31st the last day on which you can, if you choose to do so, voluntarily provide paid sick or family leave and collect payroll tax credits. Now, several questions have come from this. First, I've been getting asked by my clients the following. Scott, have any of Families First provisions been amended, right? We know that it expired. We know that we no longer have a legal obligation and that we can now choose to voluntarily provide it. but do the Act's provisions, are they still the same as they were when initially enacted on April 1st, if we do choose to voluntarily provide leave to our employees? And the answer is the provisions remain the same. Nothing has changed. In other words, the most amount of time that an eligible employee is entitled to for paid leave under the Emergency Paid Sick Leave Act, 2 weeks or 80 hours, right? The 6 qualifying reasons are still there as well. And then under the Emergency Family Medical Leave Expansion Act, same thing. That time period for eligibility has not changed. It's an individual is still entitled only to 12 weeks. Now, one other big question, and a very good question that I've been getting asked is, does this mean that, that as of January 1st, 2021, do employees' leave banks, are they replenished, right? In other words, the scenario is, if your employee already used, let's say his or her 80 hours under the Emergency Paid Sick Leave Act in 2020, does this mean that on January 1st, 2021, that employee gets another 80 hours? And the answer is no. If that employee used, if that employee used and exhausted his or her allotted leave in 2020, that individual is not considered, as of January 1st, 2021, an eligible employee. So let's go through some examples here to put this in better context. So full-time employee, right? Under Families First, a full-time employee is defined as an individual who works 40 or more hours, right? Individual who works 40 or more hours, he or she is entitled to 80 hours of paid sick leave. Now, some people say, well, Scott, we don't define a full-time employee as someone who works 40 hours. Full-time employees for us is 35 hours. Does that person still get 80 hours if we choose to provide it to them? And it's no, right? It's 35 times 2, which is 70. Only an individual who works 40 hours a week gets that 80 hours. So let's say that the full-time employee, 40 hours or more, right? He or she exhausted paid leave under the Emergency Paid Sick Leave Act in 2020. That individual, come January 1st through March 31st, 2021, is not entitled to an additional 80 hours, even if he or she qualifies. So let's say, for example, that I took my 80 hours at the end of December, say last 2 weeks, because my wife contracted COVID. And unfortunately now I've got COVID, right? So I tell you, I want to take another, I know that I exhausted my 80 hours. I want to take an additional 80 hours because now I have COVID. Are you required, right, to provide me with those 80 hours? I'm eligible, right? I mean, I qualify under Families First because I have COVID, but I'm not eligible, right? I'm not eligible because I already exhausted those 80 hours. Now, could you still provide me with those 80 hours, right? Because again, you're not legally required to. Now it's simply voluntary, right? Discretionary. You could. And as we'll talk about, if you do so, right, there's the issue of payroll tax credits. And if you do provide hours, paid leave to someone who is not otherwise eligible, you can't take the payroll tax credits. And we'll talk about that in a few seconds. What about, let's go talk about another example. So an employee, full-time employee again, who uses just 60 hours in 2020, right, under the Emergency Paid Sick Leave Act. That means that come January 1st, 2021, that individual has 20 hours remaining. So if you, as the employer, if you agree to voluntarily provide Families First to your employees, and if this particular employee qualifies for one of the 6 reasons under Families First, he or she is eligible, and you could provide them those 20 hours. Now, another big important question I've been getting is, Scott, let's say we do agree, right, as an organization to voluntarily provide Families First. Does this mean that we have to provide it for each of the 6 qualifying reasons under the Emergency Paid Sick Leave Act and also under the Emergency Family Medical Leave Expansion Act? Or can we just choose one of the reasons? And the answer is it's the latter. I've got some clients who have, one, made the decision to voluntarily provide Families First through March 31st, but they're only doing so for qualifying reason number 2 under the Emergency Paid Sick Leave Act, and that is an individual who has COVID. So they're only providing paid sick leave to individuals who have COVID. In my example, previous example, let's say my spouse got COVID, right? I would otherwise qualify in 2020, but for this client, they're not providing paid leave to that employee, right? They've chosen as an organization to provide it only if someone gets COVID, and you can do so. Because again, there is no legal mandate anymore. This is purely voluntary on your part. Now, of course, if you choose to only provide it, let's say for qualifying reason number 2, i.e. someone gets COVID, make sure you are uniformly applying that policy. When you start making exceptions, particularly amongst people who don't look like each other, that's when you get in trouble. And what I mean by you get in trouble, that now forms the basis of a discrimination claim, right? Because you're treating two people differently. And let's say it's a male and a female, you're potentially treating two people differently based on sex, right? And the difference in treatment is I'm giving one of the two paid leave. I'm not giving the other paid leave, right? And that's where you get in trouble. So make sure if you do choose to provide paid leave, and if you are going to provide it for, one or two of the reasons, so maybe it's qualifying reason number 2, and then 5, which is if your child's school is closed for COVID-related reason, which is also the only reason under the Emergency Family Medical Leave Expansion Act that you uniformly apply that. You're not making any exceptions for anybody else and providing them paid leave and then denying, if that situation arises, paid leave to another person. Okay, so let's now talk about the payroll tax credits. So if you do voluntarily choose to provide paid leave under Families First to eligible employees, you can collect payroll tax credits through March 31st, 2021. Now, this is no different than what the requirement was in 2020. Remember that the IRS and Department of Labor both stated that in order for you, employer, to be eligible for payroll tax credits, the individual must be an eligible employee, right? Which means that I must have qualified for one of the specific reasons under the Emergency Paid Sick Leave Act and or the Emergency Family Medical Leave Expansion Act in order for you to collect those payroll tax credits. That has not changed. So if you, again, choose to voluntarily provide paid leave to an eligible employee, meaning I still have time remaining, meaning I qualify for one of these specific reasons, you can collect those payroll tax credits. So using the example of the individual who used 60 hours in 2020, and if you, the employer, agree to voluntarily provide paid leave, and that individual qualifies, that individual has 20 hours to use through March 31st, 2021. You as the employer can collect payroll tax credits for those 20 hours because I'm eligible since I have 20 hours and I qualify, assuming I do qualify for one of the reasons. The example of the individual who exhausted the 80 hours, let's say you're a generous employer, you want to provide paid leave because the individual has COVID, and has no time remaining and so no company provided leave, you can still do so. But just know that if you do provide me with those 80 hours, even though I already exhausted my full allotment in 2020, you as the employer cannot collect and take the payroll tax credits because me, the employee, I'm not eligible. Right, I've already exhausted my allotted time off under the Emergency Paid Sick Leave Act. So make sure that you fully understand that concept in terms of when you can and can't collect payroll tax credits. And again, that is based on the whether or not the individual, the employee, is eligible, right, for paid leave to begin with. All right, so let's talk about two considerations under the Emergency Family Medical Leave Expansion Act that has caused some confusion for my clients, so it may be causing some confusion for you as well. So let's first talk about Families First and EFMLEA under the concept of the rolling 12-month FMLA period. So this applies if you as an organization, first of all, are subject to FMLA, and if you as an organization calculate and determine eligibility using the rolling 12-month FMLA period. So let's use an example, again, to put this in better context as it relates to what considerations you need to be concerned about. So let's say in 2020, I used 4 weeks of just normal FMLA, not EFMLA, normal FMLA in January 2020. I used 4 weeks of normal FMLA in June 2020, and then I used 4 continuous weeks of regular normal FMLA in December 2020. So by my simple math, 4 times 3 is 12. I, as of December 31st, 2020, have exhausted my total allotment of FMLA of 12 weeks. So using this particular situation, the question is, all right, as of January 1st, 2021, does that individual, is he or she entitled to, or can he or she use 12 weeks of EFMLA benefits, right? If you look at the example, the employee did not use any EFMLA in 2020. The employee only used normal FMLA, right? And we know that normal FMLA and EFMLA are essentially tied together, right? You've got to have the full 12 weeks of FMLA in order to take EFMLA. The situation here, however, with the rolling 12-month method, right? As of January 1st, 2021, I don't, because my employer is using that rolling 12-month method, I don't get a full 12 weeks again, right? Under that rolling 12-month method, we have to peel back that onion. And when we peel back the onion, we peel it back layer by layer. And so on January 1st, 2021, I'm only entitled to 1 day of FMLA because we look back 1 full year. On January 2nd, I'm entitled to 2 days. On January 3rd, I'm entitled to 3 days, so forth and so forth, such that at the end of January, using the rolling 12-month method, I'm only entitled to 31 days of FMLA. So if that, let's say, an individual today comes to you on February 3rd, right, using this particular hypothetical and says, Johnny's school, I was just informed by the principal that it is going to close and go to remote learning. I want to take my full 12 weeks of EFMLA because I didn't take any last year. Your response is, one, depending on whether or not you as an organization have made the decision to voluntarily extend it, is, Scott, you are not eligible for 12 weeks of EFMLA. You're only eligible for 31 days. 31 days because you are only entitled to, as of today, February 3rd, 31 days of normal FMLA, and those are tied together, right? So keep that in mind in terms of rolling 12-month period when that rolling 12-month period resets prior to March 31st, 2021. Now let's just use the second example I want to talk about is when you as an organization, let's say you use a calendar year to determine FMLA, right? So we're talking about January 1st through December 31st, 2020. Or I'm sorry, 21, December 31st. All right, so in my example, I use 8 weeks of continuous EFMLA in 2020, right? So as of January 1st, 2021, if my employer has agreed to voluntarily extend Families First, that means I have 4 weeks of EFMLA remaining. So the question here is, Scott, that 4 weeks, but what about the fact that we use a calendar year? So as of January 1st, the employee actually is entitled to 12 weeks of FMLA, which is true. Under your policy, the employee would be entitled to 12 weeks of FMLA. However, right, the employee used 8 weeks of EFMLA in 2020. So just because on January 1st, you as an organization, I'm entitled to 12 weeks of normal FMLA, again, that doesn't replenish my time period for EFMLA. I still only have 4 weeks available for EFMLA because I used 8 weeks in 2020, despite the fact that as an organization, right? You've given me, and I'm entitled to 12 full weeks of FMLA. So those are two scenarios that my clients have been dealing with, and it's causing some confusion in terms of how you calculate time, right? In terms of how much time an employee has to use under EFMLA when looking at it through the lens of FMLA. All right, so let's say that one, you're not subject to Families First. You have 500 or more employees. Or let's say that as an organization, your organization has made the decision that we are not going to voluntarily provide paid leave. That ended on December 31st, and thus our requirement also ended on December 31st. What are some non-Families First considerations? Because again, employees will still have the need for leave and will still want to get paid if they're taking some type of leave, particularly due to a COVID-related reason. So first and foremost, right, there's company-provided paid leave. What I mean by this is your vacation policy, your sick leave policy, or if you've merged the two together, your PTO policy. That's always available to employees to take. Consider a temporary flexible work policy. And this is more in line with for parents, right? For parents whose children are still, their school are still doing remote learning, right? There's that need, particularly if we have young children who can't be home alone. And if the individual is a single parent or there's no other adult available to watch the child, there's still going to be the need to be at home with the child, right? So I have one client, for example, who they have chosen not to extend Families First, but what they've told their employees is if you can work from home, right, if your job duties permit you, if your job duties allow for that, we'll allow you to work from home. Now, of course, that's not going to be applicable to all employers, right? Let's talk about if you're in manufacturing. Well, what's the machine operator supposed to do? The machine operator can't take the machine home, right, to work. So he or she wouldn't be, that policy is not applicable to that individual. So what have we been seeing, at least what I've been seeing through some crafty employees who are up to date on what they can do is, and jump down to the last bullet point. That employee, let's say the machine operator, who needs to be at home with the child and no one else is available to take care of the child, they've been resigning from their employment and filing for unemployment. Now, generally speaking, an individual who voluntarily resigns, and if that reason is not attributable to the employer, that individual, generally speaking, is not eligible for unemployment. IDES has been making an exception in this particular situation, however. And in order for the employee to be eligible for benefits, unemployment benefits in this particular situation, a particular fact pattern has to exist. And that fact pattern is this: that the employee needs to be at home with a child because the child's school is closed due to COVID-related reason and is doing remote learning. That's one. Two, that the child can't be home alone by his or herself. And three, that there is no other adult who is able to stay home with the child. If the employee meets and is able to show that he or she meets those reasons, then an employee who voluntarily resigns to be at home with the child while the child is doing remote learning likely will be eligible for unemployment. Now, again, that has nothing to do with you as an employer, right? There's really nothing you can do about that. That's just as an FYI in terms of what employees have been doing. Now, one thing to note here is that the machine operator may tell you, hey, I'm going to resign. But what Johnny's principal has told me is that that the school may be going back to in-person learning come March 1st. So will my job be available on March 1st? And your response is, I don't know. Right? And the employee, and not only that you don't know, but for you as an employer, this isn't job protected leave. When the machine operator resigns, this is an FMLA where the employee has job protected leave, and when that leave is up, you're required to reinstate that employee. Employees who choose to voluntarily resign, they're doing so at their own peril. So you can certainly tell the machine operator, listen, Scott, certainly if your position is still available, you're welcome to reapply for it. But if it's, we're not guaranteeing you employment. So the employees need to understand that this isn't job protected leave. They're doing so at their own peril. And quite frankly, their job may not be available to them when the need for leave ends. All right, local state paid sick leave. So in terms of, I know we're in Belleville, many of you are, surrounding area. To the extent you have locations in Chicago or Cook County, Illinois, know that there's the Chicago and Cook County paid sick leave ordinances that require you as an employer to provide 40 hours of paid sick leave. If you're not in those areas, don't worry about it. Illinois itself does not have a paid sick leave requirement yet, but to the extent you have locations in other states, for example, New York and California, I know are two amongst others that do in fact have mandatory statewide requirements that employers provide paid sick leave to their employees. So keep that in mind. To the extent you have locations in other states, make sure that you are up to date on what that particular state requires. FMLA, so what's the consideration here? The consideration here for FMLA is if someone gets COVID, right, is that considered a serious health condition such that that individual would be entitled to FMLA, either unpaid or paid. Now, I say paid only because many employers have a requirement in their handbook, and there is a company policy that says an individual who, if you are taking FMLA, you must use and exhaust all company provided leave simultaneously. That's the only reason why I'm saying paid. Generally, otherwise, of course, FMLA is unpaid. So for FMLA, let's talk about in terms of someone who's symptomatic versus asymptomatic. A symptomatic person likely may not qualify for FMLA because he or she likely does not have a serious health condition if he or she is asymptomatic. Why? Couple reasons. Two, first, that individual is not incapacitated. Right? If you're asymptomatic, you have no symptoms, which means you're not going to be incapacitated. Two, that if you have no symptoms, there's likely no need for continuous treatment, right? 3 days or more of continuous treatment. And so an asymptomatic person likely would not be eligible for FMLA for that reason. Again, case by case, case by case scenario. Symptomatic person, he or she may, in fact, be eligible if through a diagnosis of COVID, right? Depending on how severe the COVID is. If I am hospitalized for, let's say, 4 or 5 days, I'm incapacitated. And 3, there's a need for continuous treatment, right? So we're going to have to determine based on the documents we get back from the individual's physician as to whether or not a diagnosis of COVID for a particular person constitutes a serious health condition. ADA, Americans with Disabilities Act, the consideration here is an individual's COVID in and of itself constitute a disability such that we are required to provide a reasonable accommodation. Now, again, case by case, but generally speaking, a diagnosis of COVID in and of itself probably doesn't give rise to a disability under the ADA just because of the short duration of COVID. That being said, the employee may have an underlying health condition that is exacerbated by COVID such that now the individual, there is a need for reasonable accommodation based on that underlying health condition. So keep that in mind. Then STD, what I'm referring to here is short-term disability benefits. So what we've been seeing here is that employers have been attempting to amend the definition of of disability under the short-term disability policy to meet a positive diagnosis of COVID. If it's a self-funded policy, you can unilaterally do this generally. If it is a policy that is being administered through an insurance company, you can't unilaterally do this. You have to get the approval of the insurance company first. Second thing I've been seeing with short-term disability policies is employers have been waiving the 7-day waiting period. So what happens is if I apply for short-term disability, I fill out an application, I submit the application. And there's a 7-day waiting period from the day I submit the application in order for me to begin receiving benefits. So employers have been trying to waive that 7-day waiting period so employees can start receiving those benefits a lot quicker. Okay, so that is the first portion of the webinar today. Wendy, happy to take any questions on anything we just talked about.
I don't think we have any questions as of now. So if there's some at the end, I will shoot them over to you.
Okay, good. So let's continue on here. So the vaccines, right? The vaccine is finally here. Let's take a moment to just applause that. We now see the light at the end of the tunnel. It may be shimmering, but there is still that light that we can see. So the question here is, can you, as a private employer, can you require employees to get the vaccine once it is available, right? That's the question that needs to be answered. And the answer to that is generally, yes. Yes, you can. Now, notice that this is not a unqualified yes. It is a qualified yes. And we'll talk about why it is a qualified yes. But generally speaking, you, as a private employer, can require that employees receive the COVID vaccine once it becomes available as a condition of returning to or as a condition of remaining in the workplace. The EEOC has issued guidance for employers as it relates to obligations with the vaccine. If you Google EEOC guidance vaccine, this link will pop up. Click on that link, go to section K as in Kathy, and that's the EEOC's guidance on this. But I'll be talking and discussing much of that guidance here. So the big question is, right, when will the vaccine become available? Because as I stated, you can require that employees get the vaccine once it becomes available, right? So when will it become available to you and your employees? So Illinois has a COVID vaccine distribution plan, right? When I say Illinois, I mean the Illinois Department of Public Health and Governor Pritzker. CDC does as well, but we are in Illinois. And Illinois has the discretion and right to adopt its own vaccine distribution plan, and it has done so. And it is varied from the CDC's plan in one respect. And so when we're looking at what the vaccine distribution plan is, focus on the Illinois Department of Public Health, don't focus on CDC. So this is Illinois' vaccine distribution plan as of January 6, 2021. I checked right before this webinar. It has not changed since that date. So phase one was frontline healthcare workers, residents, and staff of long-term care facilities. We are now, as of January 25th, 2020, in phase 1B. Phase 1B includes frontline essential workers. According to the Illinois Department of Public Health in Illinois, that constitutes 1.3 million workers. And then Illinois residents who are age 65 or older. According to the Illinois Department of Public Health, that constitutes about 1.9 million residents here in Illinois. Now, one way that Illinois' plan differs from CDC is that CDC's phase 1B included frontline essential workers, but then it included individuals who are age 75 or older. Illinois changed that and lowered the age requirement to just 65 and older. So who are frontline essential workers? Illinois has defined essential frontline workers using the following. So that first bullet point, everybody who is in this category is considered a frontline essential worker, which means as of today, February 2nd, February 3rd, 2021, the vaccine arguably is available to them, which means as of today, February 3rd, 2021, you can mandate that your employers get the vaccine, that your employees get the vaccine as a condition of employment, subject to exceptions, which we'll talk about. Phase 1C, according to the Illinois Department of Public Health, will include, at least as of now, subject to revision, will include individuals who are ages 16 to 64 with high-risk medical conditions, and then other essential workers. Who's another essential worker? I've laid that out for you here as well. When will 1C start? It just varies. But what we've been hearing is it's estimated to start sometime in mid-March. Of course, estimated being the operative word. And then phase 2 is everybody else, right? Who's not included in 1A, 1B, and 1C. Okay, so there are 2 exceptions to the mandatory COVID-19 vaccine policy. So to the extent you as an organization have made the decision that you are going to implement or want to implement a mandatory COVID vaccine policy, know that there are 2 exceptions to when an employee can say, I am seeking an exemption to your mandatory policy, i.e., I am seeking a reasonable accommodation in the form of an exemption to our company's mandatory COVID vaccine policy. And there are the following: employees who cannot take the vaccine due to a medical disability, and employees who are seeking an exemption based on sincerely held religious belief. So what I'm going to do in the next couple of slides here is take us through a real scenario, not real scenario, but a hypothetical scenario that you may be faced with by an employee who tells you, I cannot get the COVID vaccine because I have a disability that makes it unsafe for me to take it, right? So that's the scenario that you're going to be presented with. Let's go through the steps that you're going to need to undertake to determine whether or not you could grant that employee his or her request for a reasonable accommodation in the form of an exemption from your policy. All right, so once the individual, and again, is that individual going to say I have a disability? No, but they'll likely say I have some medical condition. Once we hear the term disability, medical condition, right, red flag, because that means the Americans with Disabilities Act is implicated. So the first thing we need to know is, well, how is a disability defined under the ADA? Because if an individual does not have a disability under the ADA, we are under no legal requirement to accommodate that person, i.e. grant them an exemption from our mandatory COVID-19 vaccination policy. So the ADA defines a disability as any physical or mental impairment that substantially limits one or more major life activities of an individual. What does that mean, right? How are we going to determine, Scott, are we going to use that definition? And the answer is that's the baseline. But really how you're going to determine if an individual has a disability is by asking for medical documentation corroborating that disability, right? So go to the last bullet point there. You as an employer have a right, and this should be set forth in your handbook. The handbooks I draft for my clients have a section on requesting reasonable accommodations, and in that section, I state that the employer reserves the right to ask for supporting medical documentation to support the need for a reasonable accommodation based on a medical condition and/or a disability. So you should have that in written form in your handbook. So what we've been seeing is this. Employers, you ask, so I tell you that I need a reasonable accommodation from an exemption from the policy. You tell me, well, we need something, a note from your doctor substantiating your condition, i.e. your disability. 2 days later, you get the employee says, here's the note from my doctor. And what does that note say? It says, Scott has a health condition, has a health condition or a medical condition, and Scott should be exempted from your company's COVID vaccine mandatory policy. Is that enough? Is that sufficient? And the answer is absolutely not. What you tell the employee is, unfortunately, we cannot accept this. And the reason you can't accept it is because it does not provide us with, quite frankly, any information that we need to determine whether or not you have a disability such that there is a requirement that we provide you with your accommodation. So this is what we need from you, employee. This is what you need to tell your doctor. Your doctor needs to do one of several things. One, first, either identify what the disability condition is, or describe it in such detail such that we can make a determination as to whether or not, in fact, it is a disability. Second, the doctor needs to describe how the condition substantially limits, one or more major life activities. In other words, we need to know, employee, how this condition restricts you, right, from doing, for example, working, from doing any other kind of major life activity. Once we have that information, at that point in time, we can make a determination. You could also ask for, and I do this quite generally when I undergo this kind of task, I say, not only do we want identify or explain, also to define how it restricts you, but also, is there any accommodation such that could mitigate the effect of it? So of course, the doctor is going to say, well, yes, an accommodation, an exemption from your policy. Is there anything else, right? Is there any kind of medication that an employee can take, right, to mitigate the effects of the particular condition? And so you could ask for that information, right? And so the point here is, you're not going to just rely on the definition of disability under the ADA, because that really doesn't tell you anything. It is, what does the employee's doctor tell you, right? What is the employee's doctor telling you as to why that employee needs this particular accommodation? So what we've been seeing is, life-threatening allergies, for example, right? We've heard that in terms of anecdotally with the Pfizer vaccine, where people are getting, severe allergic reactions to a component of the vaccine. Disorders that compromise the immune system, or, severe and well-documented anxiety associated not only with side effects, but associated with just having getting a shot in your arm, right? Particularly when there's a two-step process here. So these are all case-by-case determinations, again, that should be made based on documentation provided by the employee's doctor. All right, so once you determine whether or not the individual, in fact, has a disability, right, the next step is to determine whether you are going to grant the employee's request for a reasonable accommodation, and that is an exemption from your policy. Now, we only have to do so, right, grant that exemption, unless doing so would pose an undue hardship on you as the organization, or the employee poses a direct threat by not getting vaccinated, and there is no reasonable accommodation that will reduce or eliminate that direct threat that the employee poses by not getting the vaccine. So let's talk about step 2 here. The ADA permits you as an employer to require that employees with disabilities not pose a direct threat, right, to the health and safety of individuals in the workplace. This determination has already been made for us as it relates to COVID, as it relates to individuals who are not going to get the vaccine. The Illinois Department of Public Health and EEOC have both indicated through guidance that an unvaccinated person is, in fact, a direct threat to others in the workplace. And why? Because there's the possibility that an unvaccinated person can expose others to COVID. And the EEOC has specifically stated that COVID in and of itself constitutes a direct threat, right? So we know that an employee, right, we can make the determination pretty easily based on guidance from the Illinois Department of Public Health and the EEOC that an unvaccinated person constitutes a direct threat. All right, so we have made that determination. Does this mean now that we have determined that I will constitute a direct threat because I'm not getting the vaccine? Can you automatically exclude me from the workplace? The answer is not just yet. And I've been having some clients who have been looking at this as, oh, this is a good possibility to kind of get rid of any dead weight that we have. Be very careful with that, obviously, not to make any type of determination based on a disability or even someone who you regard as having a disability. So I'll just say that. With that being said, though, before you can legally exclude me from the workplace because I am a direct threat, remember I talked about we have to first determine whether or not there's a reasonable accommodation that will eliminate or reduce me being a direct threat to others in the workplace. So how do we make that determination? Well, under the ADA, we are required to engage in what's called the interactive process. And the interactive process is you talking to the employee and determining whether or not there is an accommodation to eliminate or reduce this risk, right? So remember from when I talked about earlier in that note from the doctor, what we can require. Well, that's one of the things that we can require, right? Doctor, is there anything that will eliminate or reduce the risk of Scott, who's unvaccinated, reduce the risk of him exposing others to COVID in the workplace? And so we have to talk about and discuss and go through what are some potential reasonable accommodations that will eliminate the reduce or risk of me being a direct threat to others in the workplace. So just some points that I want to talk about with reasonable accommodations in general. Generally speaking, employees do not have the right to an accommodation of their choice. They may think they do, right? They may think they do. They do not, right? They only are entitled to an accommodation unless it is one that reasonably accommodates the disability, but more importantly, does not pose an undue hardship, right, to the company. An undue hardship is defined as significant difficulty or expense. So let's talk about what are some potential reasonable accommodations that you will need to and should consider when making the determination as to whether or not you can eliminate or reduce the risk of me, the unvaccinated person, being a direct threat to others in the workplace. So if my position and duties permit, and if my physical presence at the work site is not an essential function, right, you can allow me to work remotely. And we've been doing that with many of our employees already. So that may certainly be a reasonable accommodation. Now, the question here is, okay, Scott, but I've been getting a lot of pushback from employees who are thinking that this temporary approval is something that's permanent. And the answer is no, it's not permanent. This is in fact temporary, right? So a temporary approval where you allow someone to work from home remotely temporarily, this does not negate the physical presence requirement, right? So to the extent you say we're only temporarily allowing this because, Scott, your position, really you need to be here at the office, at the facility to do your job. And by us temporarily approving you to work from home remotely, this does not negate that requirement. We're doing so for a health and safety reason because, quite frankly, by you not getting vaccinated, you're a direct threat to others in the workplace. I'm not going to use those specific terms, but you know where I'm going with that. So just know that a temporary approval of allowing someone to work from home remotely, that does not mean that you have to automatically approve that indefinitely, right? Because employees are saying, well, hold on, why do I have to come back to work? You're already allowing me to already allowed me to work remotely. And the answer is because your job requires you to be here in the workplace. That's why, right? And or because, quite frankly, you're not efficient at home, right? So there's many reasons why this is just a temporary approval, right? That is not something that needs to be indefinite. All right, so second point here is something that I think it's going to be very difficult for you as an employer to kind of overcome, and that is essentially status quo, right? And status quo is requiring the person to come to work, requiring the person to maintain social distancing, requiring that person to continue wearing masks. And the employee may say to you, employer, how am I a direct threat today when I wasn't a direct threat yesterday, right? And I've been wearing a mask, I've been adhering to social distancing guidelines, and by all accounts, there have not been any positive cases of COVID in the workplace. So why are you excluding me now when you didn't before? When I have agreed that I will continue wearing a mask, I will continue maintaining social distancing. And that's a very good point. That's a very good point by the employee, and one that's going to be very difficult for you as the employer to overcome, because that is, maintaining status quo. That would be a reasonable accommodation. continuing to wear a mask, continuing to social distance, and arguably that may not eliminate, but certainly reduce the risk of me, the unvaccinated employee, of giving COVID to others in the workplace, so long as I, in fact, have been maintaining and wearing, social distancing and wearing a mask. Now, let's change the facts a little bit. What if the individual is unable to wear a face mask or covering due to a medical condition? Well, in that situation, right, while you may be able to social distance, you can't wear a mask, right? And I think there's a legitimate and good faith argument to say in this situation, since you cannot wear a mask due to a medical condition, that we cannot allow you to come to work because we cannot eliminate and or reduce the risk of you contracting COVID in the workplace. Quite frankly, we've been scared, the whole time, right? Because you can't wear a mask. And so I think that presents a different scenario where arguably an employer may have a good faith argument that, to exclude someone in that scenario because you can't wear a mask, right? And you still pose the risk of giving someone, if you contract COVID, of giving it to others in the workplace. So that is a different scenario. So other things you have to consider is, shifting unvaccinated workers to other workplace roles, maybe that have less contact with others, or relocating work sites within a building to reduce contact with others. At the end of the day, this is all dependent on your company, on the employee, and the employee's duties and job responsibilities, right? There's no one size fits all approach here. It is a case-by-case determination that the end result will be a byproduct of you engaging in that interactive process, again, to determine whether or not you can eliminate or reduce the risk of me, the unvaccinated employee, posing a direct threat to others in the workplace. So if you do come to that conclusion, right, so I can't wear a mask, that cannot be, right, that the direct threat cannot be reduced to an acceptable level. At this point in time, you can, in fact, exclude me from physically entering the workplace. Does this mean, however, that the employee is automatically terminated, or that you can, I should say, automatically terminate the worker? The answer is not just yet, because there's other things we have to consider, particularly if you are an employer who is subject to FMLA. So the scenario here is, one, I've got some type of health condition or a disability that I cannot take the vaccine. I cannot get the vaccine. So the question here is that condition, that disability, is that a serious health condition under the FMLA? If so, then you as the employer have a affirmative duty to offer me FMLA. You can't say, well, listen, Scott, why delay the inevitable, right? We know that this is a permanent condition. And at the end of 3 months, that condition's not going away. So let's just, agree through a handshake that your last day is going to be today, right? So we don't have to give you FMLA. Can't do that. Because once you as the employer have knowledge that a condition may qualify as a serious health condition, you have an affirmative duty to offer FMLA to the employee. And the flip side to that is the employee may say, listen, I don't want to take FMLA because I may not be eligible for unemployment benefits. And as you said, and as I told you, my condition is permanent, right? At the end of the 3 months, it's not going away. In that scenario, can you decide to part ways like that? The answer is no, you cannot. Even if the employee affirmatively tells you, I don't want FMLA, you still have an obligation to provide them the forms to see whether or not they in fact have a serious health condition. But what you can do, right, is once you provide those forms, right, the certification forms, the employee has 15 days to return them. And if the employee doesn't return the forms in 15 days, well, at that point in time, then there can be a mutual parting of the ways, because then you've dotted your I's and crossed your T's, right? You've offered FMLA, you've provided the certification forms, you've provided the employee with 15 days to return them, and in that situation, the employee has not. Well, you've done everything you need to under the law, and you can then terminate the worker if, in fact, that's what you want to do. Regardless of how you choose to proceed, whenever you're going through each step in this analysis, make sure that you are documenting it, right? Particularly if you, at the end of your analysis, have made the decision you are going to exclude or terminate someone. Just know and be prepared that that likely can cause a lawsuit. I'm not saying that the employee has a good or merit, a claim that has any merit whatsoever. But as we all know, an employee doesn't necessarily need a claim to have merit in order to file a lawsuit against you. They will still do so anyway. So make sure you have documented, you have the proper documentation, you have a clear explanation as to why you're choosing to do what you're doing, because that is our best defense to any type of lawsuit. All right, so let's transition now to the second exemption, and that is the religious exemption. Know that with the religious exemption, you are still going to go through each of those steps that I just talked about under the medical exemption, right? So we're going to determine whether or not it's necessarily held religious belief. We know that the employee is a direct threat. We're going to determine then whether or not there's a reasonable accommodation that will eliminate or reduce the risk of that unvaccinated person being a direct threat. So those steps that we talked about for the medical exemption, they still apply here with religious exemption. You still have to go through those same steps. All right, so let's just talk about some considerations here. So the scenario you're going to be confronted with is the employee telling you, I cannot get the vaccine based on my sincerely held religious belief that prohibits vaccination. So what is the employee telling you? The employee is telling you, I belong to a particular church, a particular religious denomination, we're affiliated with a particular religious group, and we do not believe in vaccinations. We believe on and rely on only faith-based healing, right? So can you, right, just like with the medical exemption, where the first step is determine whether or not someone has a disability, the first step in this analysis is determine whether or not someone in fact has a sincerely held religious belief. Now, know that the EEOC permits you as the employer to make a very, very limited inquiry into determining whether or not someone has a religious or sincerely held religious belief. And it is a very limited inquiry because it is an extremely easy threshold for the employee to meet. And I always describe it to clients this way. Unless you can somehow establish that I am pulled out my religion out of a Cracker Jack box, I, as the employee, will be able to meet this threshold because it is this easy to meet. If I provide you with any type of written material, but for something that was pulled out of a Cracker Jack box, I have met my threshold. So I can go to the internet, download something that says that that this religious organization does not believe in vaccinations. You have to accept that, and the employee will have met that first threshold. If I verbally tell you that I was at church over the weekend and my pastor has reminded all of the congregation that we only believe in faith-based healing, that is enough. I've met the threshold. If I provide you with a text message, let's say, right, that may be enough. Of course, you can determine whether or not who that text message is coming from to make sure it's not my wife, right, that in fact it's the pastor. But it is so easy for employees to meet this threshold that, again, I've been maybe one or two situations where, my advice to the employer has been, yeah, let's not accept that because it's just nonsense. But generally speaking, employees are able to meet this. So the other thing I want folks to know is that there is a distinction with a difference between your duty to accommodate someone based on religious or medical reasons and your duty to accommodate someone based on a political reason, a scientific reason, or personal views. So for example, if one of your employees says, well, I'm not going to get the vaccine because Trump said not to get it, right? And I am a true Trump believer. So if Trump said he's not getting it, I'm not getting it. Or if your employee says, well, I was reading some journal that I think is a medical journal online, and I read that this particular medical journal, the guidance in here is that there's so many side effects that it causes you to grow two heads if you get the vaccine. Or if the employee says, listen, for personal reasons. So if I tell you the Cruz household has made a decision as a family, we are not getting the vaccine, so I'm not getting it. Your response is too bad. You get it, or you're no longer employed here. And you have the right to do that because we do not have a duty to accommodate political views, scientific views, personal views based on an employee's refusal to take the vaccine, unless it is a medical or religious exemption, which then requires us to go through the interactive process. If it is not medical or religious, but political, scientific, personal, no duty to accommodate, no duty to go through any of the steps we talked about. It is this is our policy. I understand what your personal views may be, but if you want to remain employed here, you will get the vaccine shot. And if you choose not to, you will no longer be employed here. Simple as that. Okay, so a question I've been getting a lot is, Scott, we want to implement a mandatory policy, but we have been getting questions from employees who already had COVID, or they currently have COVID. And they've been asking us, are we going to be subject to this, the mandatory policy? Because quite frankly, we've already had COVID. And the answer is yes. They should be subject to the policy. And this isn't me speaking as a lawyer. This is me relying on advice and guidance from the experts. And the experts that I'm referring to are the Illinois Department of Public Health, Dr. Fauci, and the CDC. And so what these experts have been saying is that these employees who already have had COVID or have COVID currently, they should be subject to and should still get the vaccine. And the reason is this. Right now, what we know, at least the guidance shows, is that there's a 90-day period, right? So after you've recovered from the vaccine, from COVID, there's a 90-day period where it's highly unlikely, right, that you'll get COVID again, that you have immune protection for 90 days after you recover from COVID. But after those 90 days, you still could, and we've seen examples. I have clients who are in healthcare, who've had healthcare workers who've gotten COVID twice. They still could get COVID after that 90-day period. And so those employees, right, even though they've had COVID or currently have COVID, they should still be subject to your mandatory vaccine policy. Now, what you can do, let's say, for example, that you're going to implement a policy that says everybody with the last name A through M as in Mary, you've got 2 weeks to get it, right? Hypothetically. And then N through Z, you've got 2 weeks to get it. Well, if you had COVID, right? And let's say Scott, the employee just got done with, recovered from COVID and came back to the workplace on Monday, Scott, you can wait 90 days, right? After the 90-day period, you can get it. Or you can say, you don't have to wait 90 days. We want you, Scott, your last name C, you're lumped in with everybody else whose last name is C. So you've got 2 weeks to get it, right? Entirely up to you. But the point being here that employees who have COVID or had COVID, they should not be exempt from your mandatory policy. Okay, the other question I've been getting is if we do implement, or let's say do implement a mandatory policy or make it highly suggestive that we do get it, right? Does that mean that those policies replace our mask policies, replace our social distancing policies, or do they just supplement? And it's the latter. They supplement, they don't replace. Again, this is guidance from the experts. The experts being CDC. OSHA, in fact, came out with guidance on the end of January that adopted CDC's guidance. And what essentially CDC is saying is that even if someone gets the vaccine, right, there's still so many unanswered questions in terms of immunity. And in fact, whether or not someone is immune from getting COVID again and giving it to someone else, right? What we know, at least there haven't been tests for, and maybe they're doing it now for Pfizer and Moderna. The only vaccine that's not available here in the US is the AstraZeneca vaccine. In the UK, they actually did conduct a test, and the test there showed that there is a sense of immunity from from contracting COVID, but that's for the AstraZeneca vaccine, right? So CDC says, listen, we just don't know enough in terms of immunity once you get the vaccine, right? And so because of that, even when people get the vaccine, employers, you still are required, you still should require they wear masks, required that they social distance, right? Until Fauci tells us, and until Pritzker, Illinois Department of Public Health tell us that, hey, we've achieved that level of herd immunity where we no longer need to, right? Now, in that situation, what happens to the people who didn't get the vaccine, right? Can they now, do they no longer need to wear a mask, social distance? And the answer is no. They should still be subject to your policy, right? And the reason is because they still pose a direct threat. They didn't get the vaccine, right? And COVID, right, we've reached a certain level of herd immunity, is still going to be out there, right? They can still get it and still give it to other people. So someone asked, well, aren't we discriminating against people, right? Those who got the vaccine and those who didn't. And the answer is no. You're not discriminating, because whether you get the vaccine or not aren't protected classes, right? There's nothing under Title VII or the Illinois Human Rights Act that gives protection to someone who got the vaccine or didn't get the vaccine, right? And so individuals who don't get the vaccine, quite frankly, you can require that they indefinitely, right, wear a mask, indefinitely social distance until you believe as an employer that we're out of the woods, right? That there is absolutely no chance of anybody getting COVID anymore. Okay, so the other question I'm getting is, can we require proof of receipt of the COVID vaccine? So we are going to implement a mandatory policy, but how do we regulate this, right? How do we know whether or not our employees even got the vaccine? And the answer is, you can require that employees provide proof of a receipt of a COVID-19 vaccine. Now, one thing to keep in mind is that's all you need, right? That's the only information you need is, did Scott get it? And on what date did I get it? You do not want and should not be asking for other information, right? So just like when it's our first time at a new doctor, when employees are getting the vaccine shot, many of them have to fill out, like a questionnaire, let's say a 3-page questionnaire, in which they are disclosing other medical conditions, other medical information. You don't want that, nor are you entitled to that. So to the extent you are, for example, partnering with a third party who is giving the vaccine shot and asking that third party to, hey, whenever one of our employees does get the vaccine, can you let us know? Make sure you tell them, all I want to know is Scott Cruz got the vaccine on February 3rd, 2021, right? You don't want any other information. Quite frankly, they shouldn't be providing you that information, any other information, because that'd be subject to HIPAA, right? And if they're administering the vaccine shot, that third party is subject to HIPAA and would need a release from the employee to provide that information. So be very clear with your employees and whoever third party is administering the vaccine that, listen, all I want is that employee got it and the date he or she got it on. Okay, so let's talk about some legal considerations here. Depending on what you're going to do, right, either make it mandatory or not, make sure, just like with all other policies, you are uniformly applying that policy. So, if you're going to draw a line in the sand with who gets the vaccine, or people who are refusing to get the vaccine, make sure it's even-handed, right? So, for example, I have a client who has office staff and warehouse staff. Office staff is working remotely, so they've told them, as of right now, we're not going to require it for you. But warehouse staff, you're here every day, we're going to require it of you. Right now, office staff, eventually, when we do want you to come back, you're going to have to get it, right? But you are they're applying that policy uniformly. Once you start making exceptions to policies, that's when you get yourself in trouble vis-a-vis discrimination claims. All right, the act under consideration I want you to be aware of is the National Labor Relations Act. Now, some of you may be saying, well, Scott, that doesn't apply to me because we don't have a union here. But know this, that National Labor Relations Act applies to you as well even if you don't have a union, because National Labor Relations Act applies to both union and non-unionized workforces. So the consideration here refers to what's called Section 7 of the National Labor Relations Act. And under Section 7 of the National Labor Relations Act, employees have the right to engage in what's called protected concerted activity. And they can engage in protected and concerted activity when the impetus is to improve their terms and conditions of employment. So let's talk about some examples where we may see protected concerted activity. So let's say you do implement a mandatory vaccine policy, or let's say you choose not to implement a mandatory vaccine policy. Inevitably, what's going to happen? Your employee will go on social media. Your employee will identify who they work for because they always feel the need to do that. And they'll say something that we don't like, right? Something to the effect of, I can't believe, well, first of all, I work for this employer. And I can't believe that this employer is not requiring everybody to get the vaccine. They clearly don't care about me or my coworkers and our health and safety. Otherwise, they would have implemented a mandatory vaccine policy. Oh, and by the way, don't use this employer to go to their competitor. Obviously, we don't like that. Obviously, we don't want that. Can you take action against that employee? I would caution against it, because if you do, you're likely going to be subject to an unfair labor practice charge under the National Labor Relations Act. What that individual said on social media, as much as we don't like it, that constitutes protected concerted activity. The individual may have anointed him or herself as the spokesperson for everyone else. And what that person is talking about is, conditions of employment, health and safety. That is protected activity. So what you want to do is, talk to the employee, say, we've learned that you've made this post. Let's talk about and discuss your concerns, and let's see if we can come to an amicable resolution. At the end of the day, you can't require the employee to take it down. I mean, if you do, again, subject to an unfair labor practice charge, you can ask, you can tell the employee in the future, prior to making such a, social media post public, why don't you come talk to us first, right? So we can discuss your concerns. Now, could you still take action? You could, right? Because you may say, listen, I'll take the unfair labor practice charge. We can't have this type of employee, or we don't want this type of employee in our workplace. You could, just know that you're likely to be subject to an unfair labor practice charge. If you do have a union in the workplace, and if you are choosing to implement a mandatory vaccine policy, know that you likely have a duty to bargain with the union prior to implementing that policy. I say likely because I'm not privy to your collective bargaining agreement, so I don't know what's in there. One thing to look at, though, is the management rights clause, right? Is there anything under the management rights clause that gives you the authority to unilaterally implement such a policy? I don't know. That's a decision that you and your attorney should come up with. We'll need to make that determination. But more likely than not, there isn't any other provision in the collective bargaining agreement that discusses vaccines, right? Unless you recently negotiated your CBA, let's say in the past 6 months, would that have even been a thought to include that in there? So either way, one, it's likely going to be a mandatory subject to bargaining. Two, even if you're unsure, I'd still give union a heads up, because you know that, if there's a possibility their members could be disciplined or terminated, they're not going to be happy with that, and they're going to want to talk to you anyway. So just get it all out there, discuss it with the union, and hopefully you can come to some resolution. All right. Additional legal considerations, workers' comp. So there's two things I want to talk about here. One is related to COVID itself, and the other is the vaccine. So as relates to COVID, remember that back in 2020 in June, the Illinois Workers' Comp Act was amended to include a rebuttable presumption for employees who filed a claim based on COVID. And that rebuttable presumption essentially gave the employees a right, or essentially alleviated the initial burden to employees to prove that they in fact contracted COVID in the workplace. And that now was that burden was now on the employer to prove that the employee did not get COVID in the workplace. So that rebuttable presumption only was for COVID. It was initially set to expire on December 31st. That has been extended to June 30th, 2021. So to the extent one of your employees gets COVID, to the extent they file a workers' comp claim, the rebuttable presumption still exists, which means the initial burden is on you, the employer, to rebut the presumption that in fact the employee got it in the workplace. How do we do this? Well, there's a couple reasons. There's a couple ways to do so. The first, if I haven't been in the workplace in the past 14 days prior to contracting COVID, well, I couldn't have got it from the workplace, right? Second, that the employer, you as the employer have been complying with a local CDC, with a OSHA guidance as it relates to COVID in the workplace. Now, if we were in person, I would take a poll and say, how many of you have in fact been complying with all of the local guidance? And I'd venture to say that likely many of you have not. And just, you haven't for whatever reason. And you need to. And the reason is because that is going to protect you, right, from workers' comp claims. That is going to protect you from any type of lawsuit that employees file against you, right? If you can establish that this is what CDC says we need to be doing in our industry, we're doing it. This is what OSHA says we need to be doing, and we're doing it. This is what Illinois Department of Public Health says we need to be doing, and we're doing it. We check all the boxes. Guess what? You've now got an affirmative defense to likely one to a lawsuit, but more importantly, to the individual's workers' comp claim. You've now rebutted that presumption. And third way you can rebut it is if the employee was exposed to another source. So for example, let's say my wife had COVID 3 weeks ago, and then sure enough, I get it, I get it now, right? You would say, listen, Scott took family's first leave because his wife had COVID, clearly didn't get it in the workplace. When he came back, he had COVID, he got it from her, not anybody else. So the next consideration with workers' comp is as it relates to side effects from the vaccine. Right. And the question here is, are these compensable workplace injuries if someone does suffer a side effect? So take it in two steps. Is it a workplace related injury? Well, if you make it mandatory, yes, because my argument is, well, if I didn't work for you, I wouldn't have gotten the shot. Right. But you've made it a condition of employment. So yes, it is a workplace related injury. Second question is it compensable? The answer is we don't know yet, right? Some of the side effects have been lasting just for a couple of hours. Is the Workers' Comp Commission going to give someone benefits because they had a side effect for a couple of hours? I don't know. Hopefully not. To the extent the side effect lasts a lot longer, right, and I'm incapacitated, probably. So we'll have to wait to see how the Comp Commission handles that. All right. So the last couple of slides here, just for time purposes, kind of go through pretty quickly here. We now know kind of the information we need. And so the next question is, should we require the vaccine, right? I've listed 4 things here. There's many more that, considerations that you as an organization will have to discuss amongst yourselves as to whether or not you want to require the vaccine. Just want to focus on the last one there. Remember OSHA's general duty clause. Under OSHA, we have a general duty to provide a workplace free from recognized hazards that could cause serious harm, right? So if I'm an employee, what am I arguing then if you don't implement the mandatory policy? Well, employer, you've breached OSHA's general duty clause, right? By not implementing a mandatory COVID-19 policy, right? You are failing. You've breached your duty to provide a workplace free from recognized hazards that could cause serious harm, i.e. COVID. So we've seen those claims popping up recently. So that is something to keep in mind if you are trying to make a decision as to whether or not to implement a mandatory policy. Flip side to the coin, of course, is, well, we know that we can, subject to 2 exceptions, but should we, right? The answer is, well, maybe not. Some considerations here, employees have been saying, even healthcare workers have been saying, hold on a second, this vaccine was approved way too quickly. I'm going to wait and see, we're going to wait to see till what happens with, 3 months, 4 months from now for individuals who got it in January. So we don't think there should be a mandatory policy just yet. Maybe in 4 or 5 months, if people haven't grown 2 heads, then yes, then you can implement a mandatory policy. But until then, no. What if you have one of your high performers, right, who says, listen, I'm bringing you every year about 2 million in business. I'm not getting it, right? Too bad. What are you going to do? Are you going to terminate your highest performer who's bringing in 2 million a year? You're likely not. So either way, right, gets me to my last slide here. Is that before you decide to do anything, right, build a buy-in and plan to conflict for conflict resolution, because whichever way you choose to go, right, mandatory or not, there's going to be some likely dissension in the workplace, right? So what are some of my recommendations? If you either choose to make it mandatory or not, let's say you just really want everybody to do it but aren't going to make it mandatory, lead by example, right? Publicize, hey, all the C-suite, upper management got the vaccine, right? But for some maybe, an hour of some minor discomfort afterwards, they're fine, right? They haven't grown two heads. If you are going to make it mandatory, make sure to inform your employees in advance, right? Don't at 12:30 on February 3rd, send an email out or send a memo out or hold a team huddle and say, hey, by the way, just so you know, as of tomorrow, February 4th, we're obviously in 1B, A through M, you're going to be required to get the vaccine, right? You're going to get a deer in headlight look from many of your employers. Talk to them beforehand so you can have an open discussion about it. Obviously, the clear communication. To the extent you want to mandate the vaccine or make it, highly suggestive that people do, tie it to some visible change in the workplace, right? Of, hey, if everybody gets the vaccine, remember how everybody used to love having those potluck lunches? Remember how everybody used to love celebrating everybody's birthdays? Well, we can get that, right? We'll do that again, but everybody needs to get the vaccine first. Provide accurate, reader-friendly information. There's a lot of disinformation out there. One client, what they're doing, which I think is great, they had a meeting with their employees to gauge what their thoughts are. There were many concerns about the vaccine. And so what they're doing is they're holding a Zoom call with a healthcare professional in the area. And so this healthcare professional is going to answer any questions employees may have. Obviously not affiliated with the company, it's a neutral party. Pay for the administration fee for the vaccine. We know the federal government is picking up the tab for the shot itself, but individuals or third parties who are vaccine providers, right, they can charge an administration fee. So if you are making it mandatory, know that you do have to pay for that for employees under the amendment to the Illinois Wage Payment and Collection Act in 2019 on what are necessary and reasonable business expenses. Well, that's one, right? You have to get the vaccine to work here. It's a $20 fee. You have to pay for that. If you make it voluntary, you don't have to pay for that. But maybe you should, right? Maybe you should if you really want everybody to get it. I have some clients who are providing 1 day, 2 days of paid leave available after each COVID vaccine shot. So if I get the shot today, I get 1 day, 1 paid day off tomorrow. And then when I get my second shot, I'll get 1 paid day off as well, right? Give them some incentive. Provide gift cards, right, of modest value, right? EEOC has some guidance on what you can, how you can incentivize employees for wellness programs. They haven't come out with guidance yet as it relates to the vaccine, but their guidance is generally is you can give a gift card, but it's got to be of modest value. So I've got some clients who are providing, a $25 gift card, an Amazon gift card to employees to try to get them to get the vaccine if they're not making it mandatory. Okay. So that concludes the webinar. Wendy, I'm happy to take any questions to the extent there are any.
Sure. The one question goes back to the beginning when you started talking about the vaccination and the different workers in the industry. So it says for the vaccine for phase 1C essential workers, does that include all workers in the industry listed or just holding a specific title? For example, is an administrative assistant for a public works department eligible in that phase, or a food service worker? Would it include restaurant servers and kitchen staff?
So great question. As of right now, we don't necessarily know the answer to that because Illinois Department of Public Health hasn't finalized who, in fact, is going to be included under 1C. So we know the general groups, but we'll have to wait until, so if you look at Illinois Department of Public Health vaccine distribution plan right now, while they do give possible groups for 1C, what they have affirmatively stated is this who's in 1A specifically, this who's in 1B specifically. So once they do formally adopt a plan for 1C, then I think that question will be answered. So I don't want to necessarily tell you yes or no because I don't know. And that's going to be up to Illinois Department of Public Health once they do formalize the groups for 1C.
Okay, and it looks like that was the only question that's in the chat box right now. I know that's a lot of information that you just provided to process. And so I know that, like I said, we are recording this. So Scott, if they have questions, are they able to reach out to you directly?
Yeah, certainly. So here's my contact info. To the extent you have a question about something I said, feel free to reach out. Happy to clarify anything that you may have been confused on over something I said. 'Cause I know, again, a lot of information. So want to make sure that you get your questions answered. We also have just a lot of great resources at Greensfelder that are free to everyone, even if you're not a paying client. You all should be at some point in time, but to the extent you're not, feel free to go to our website, www.greensfelder.com. These are resources, our blog posts. We have a Simply HR blog. We have a COVID resource page that's free and available to everybody.
Okay, and it looks like just one more question came in, Scott.
Sure.
On the PowerPoint, are you willing to provide the PowerPoint as a resource too, or do you want them to reach out to you directly?
Wendy, I can send you the PowerPoint. That's fine. I'll email it to you.
Okay, thank you, Scott.
You're welcome.
Okay, I just want to thank everybody for joining us today. I really want to thank Scott for his time. This is the second one I know he's done for us, and I'm sure as things change, we can reach out to him for more information. We just appreciate you guys all as members and know that we are here for you. Again, we did record this information, so it will be available for you to re-listen to it or go to the parts that you need to. And we hope that we get to see you soon. But thank you for your time, and Scott, thank you for your presentation.
You're welcome.
Everybody have a great day.